Good afternoon, dear colleagues. I think we must begin our roundtable. Welcome to the roundtable on subsoil use. It has become a tradition to hold such a roundtable as part of the St. Petersburg Legal Forum, dedicated to the narrow issue of legislation and law application in the case of subsoil use. The focus this year is on legislation and overcoming administrative barriers to business in the exercise of subsoil users' rights. And we will try to identify those barriers to see where we are going in terms of our regulatory activities. I will make a few initial points to characterize what is going on in the legislation on subsoil today, concentrating on issues of principle. The Russian law on the subsoil is rather stable, and it has been centered on the law on the subsoil. It is rather conservative and is not really amended in a substantial way, although changes made now and then to introduce different regulation of certain categories or areas of the subsoil. After isolating subsoil areas of federal significance, we are confronted with separate legislative regulation of both the subsoil use and all kinds of legal relations. We see the emergence of special regulation for the continental shelf, for offshore development, because there are certain types of subsoil use which are different from others, and all relevant laws are being developed with the special tax regimes, special environmental issues like oil leaks and environmental monitoring. Everything is subject to regulation, and a number of issues arise in association with the legal status of offshore facilities. There are all kinds of ownership relations that are taking shape. So this is what makes it different from the rest of the industry. And the next issue we find in the Russian law on the subsoil is the isolation of new, earlier unregulated objects of regulation. And here I mean geological information, geological data. The attempts to regulate the circulation of geological data that the government and the Ministry of Natural Resources is undertaking are revolutionary things. To some extent, it is for the first time that the notion of geological data is defined with a breakdown into categories and relevant regulation practices or formats, and there are now rules for the circulation of those data. For example, after 5 years of reporting some data, the subsoil user that owns it will lose the title to it, its ownership of it, and this has to be assessed in terms of risks incurred by companies. That's what a bill incorporates. But the law on the subsoil does not contain a certain important issues like mountain property or ownership of certain facilities and other issues that have yet to become the object of regulation and thus become a source of administrative barriers. When we try to resolve certain issues not in a systematic way but in other laws and rules like land use, this mosaic will give rise to contradictions and gaps. That's another tendency, and I think we need to mention two more points today. We need to mention the development of judicial practices in a very explosive way, whereas 5 to 7 years ago we were unable to find answers to certain issues. Now we are talking about well-developed judicial practices on many issues, the criteria that authorities should go by, like in issues of early termination of land use rights and titles. That's our agenda we are working with in an established way. The new things that I can see today include one specific phenomenon, that of administrative instructions and assignments, which in fact change the practice and procedure prescribed by the law. And here I mean the instructions of the government associated with licensing that in some cases change the entire procedure of bid consideration or license applications. So this is the practice of law application which forms the landscape of our operation. The extent to which it is right in legal terms is something to be considered, and we need to see what we should do to minimize the risk of non-legal solutions. That is the diagnosis of the existing system I was going to make, and if you look at some of the slides of my prepared presentation, these are samples of local regulation. For example, the law on the continental shelf and here are 5 projects now considered by the government, and the practice of registration of various items of regulation. And to sum it all up, if we talk about the sources of administrative barriers and ways to overcome them, a lot of attempts have been made to overcome them, and to some extent they have been institutionalized. In March 2014, large-scale meeting with the involvement of all key market players was held at the Russian government and chaired by Vice Premier Arkady Dvorkovich, and two serious interagency groups have been set up whose mission is to remove administrative barriers. That's group in the Ministry of Natural Resources and Ecology, and another group, the other group which we initiated, will operate under the Ministry of Construction, which has to do with urban development, expert assessment, and so on. So we are now defining the agenda. We collect all proposals, and we plan to find solutions in the future in terms of norm interpretation and law enforcement. And I hope that we will identify some of those issues today at this round table and have a discussion. I think there's enough time for that. So permit me now to give the floor to the first speaker of this panel, and that's Roman Kvitko, Director of Department for Legal Support of Corporate Projects, Gazprom Neft. Thank you very much. It's a pleasure for me to take part in this roundtable representing some 80% of the oil reserves of this nation. I couldn't give you the figure for the entire world. So I think it's going to be a good debate. And to carry on the idea my colleague has raised, I would like to tell you about what we are confronted with in our everyday activities and what problems or solutions we see. Let me start by saying that subsoil use has not been introduced in law since a long time. It's about 20 years old, because previously there was no licensing, no oversight, no environmental monitoring or control. There were no institutions that there are now. And in 20 years since the 90s, legislation developed rapidly, but that gave rise to a number of problems and issues. Over 300 regulatory acts are there for the industry, which is a bit too much or too many. And although there are 300 documents, they are lagging behind the development of the industry. They answer the questions of yesterday and are in bad need of improvement. They are behind the market's requirements. In principle, the law on subsoil use is subdivided into three parts. That's receiving the title, to use the exercise of the title, and the termination of the title to use the subsoil. And what is especially pressing today is the regulation of offshore production. Briefly, this slide enumerates the problems we are having. This includes the procedure for filing papers or requests. So I could give you the example of combined petitions, but change a license, you need first to terminate a legal entity or to dissolve it, but you see the risk. What if you disband a legal entity, but then your license is not issued? Then there are complex procedures for amendments to the license agreements. For example, you've signed an agreement, you've arranged it with a state that you've come to terms with the state on certain terms of land subsoil use, but then something needs to be changed, and it's several circles of hell that you have to go through. Now, so there's also the issue of formation licenses. For example, in Yamal-Nenets Okrug, historically, licenses used to be issued for specific formations. You can imagine how many such formations there are in the Earth's crust, and in principle, when there's something like that, the license is issued and it applies to any depth until the nucleus of the Earth. For example, you realize that there's an oil reservoir under a formation, but you cannot drill further than that. You've probably heard the story of stranded oil deposits. For example, in our north, we have the so-called Bajan Sweet, which is below the regular level, or the Bajan of measures, and for us to reach them, those measures, we need to obtain a new license, and you can imagine what it takes. Another issue is that of the oil fringe, because there are not so many regular oil deposits. There are normally oil and gas condensate deposits. Historically, oil and gas are produced by different companies, and because technically they are different businesses involving different approaches and many other different things. But de facto, it's mixed in the subsoil. For example, an oil deposit has a gas cap, or there's gas condensate, which is a product close to oil in its physical parameters, properties, and if you look at it in the reasonable way, reasonably, you should produce all of it. You should extract all of it from the subsoil and take a comprehensive approach. And the optimum way, in economic and technical terms, would be to make an integral development project. For example, here you've got the oil and here you've got gas, but the license is one, and so you could let operators work on the oil deposits you've got, but this is going to be difficult if you cannot allow the operator to become owner of those reserves. And the optimum thing is we need to consider divisions of fields. For example, there's one area, but for different minerals, different licenses are issued. Now, the continental shelf, it's our favorite subject, together with Rosneft, because we are some of the few companies that are licensed to work on the continental shelf of Russia, and there are huge prospects here because there are tremendous offshore deposits, not only in the Arctic but also in the Sea of Okhotsk, and it's comparable to the industrialization explosion of the 1930s because it creates absolutely new prospects, new industrial areas, and that's important for demography, the economy, and everything. And one must point out that our company was the first this year to ship oil from Priraslomnoye, the Priraslomnoye Arctic field, and regulation of legal relations in the offshore lags behind actual practices. And what has been developed for land deposits, for land fields, is unapplicable to offshore development. And let me show you this. There are limitations. You know that Article 9 of the laws, the subsoil, limits the composition of land uses, subsoil uses for offshore drilling and development. Then the status of a floating platform is regulated by the maritime code, but if this platform is flying a Liberian flag, then it is regulated by Liberian law. But as soon as it is fixed in the offshore, it becomes an installation under Russian law. So there's a conflict of rules and standards, and under Russian law, Russian jurisdiction is applicable to it, including administrative and safety requirements, and it also becomes a territory of the customs union. You may remember when our Priraslomnoye platform was difficult to qualify as either a vessel or a non-vessel. If it's a vessel, then Greenpeace activities there was an act of piracy, and investigators were had a hard time deciding what it was. And there's a competition of legal norms and standards, and there's a competition of the supervisory bodies. There are gaps in the legislation, and those authorities pursue different interests. So we deal with every problem on a case-by-case basis. Now, taxation. As regards taxation, the situation is improving. Special taxation has been introduced for sea deposits, but for the law to begin to work, a number of regulatory acts needs to be developed. Now, customs, special customs procedures have been introduced, and that and customs clearances has its differences, and one could save 25% of the customs costs, but the procedure is not has not been completely elaborated. Now, when someone, it's of interest that when someone flies to a sea platform, they cross the national border of Russia. They have to present their passport at the border checkpoint. They risk becoming non-residents if they are Russian nationals, and they risk paying a 30% non-resident tax, and so on. And I thought about what they are trying to do, what they are fighting. It's difficult to imagine that some international wrongdoer is going to seek refuge on an offshore platform. I think that's something redundant. As for, well, we can only welcome the tendency in favor of well-balanced and considered regulation of the industry, and we hope that a bill will be passed shortly for liquidation of funds for excavations. There are all kinds of excavations, waste heaps and stockpiles and banks of waste, and now we've got some law on how this could be done away with. And geological data is also something that has been mentioned. So what are the gaps to be filled? I think the global issue is the status of legal relations in this area. Look, on the one hand, licenses are issued by government authorities. This is public legal relations. But isn't there an aspect associated with civil law? For example, if you pass a license to your subsidiary, you have to compensate it for something like transfer pricing or the cost of title transfer. When this issue was considered by the State Committee in association with Ulyanovsk-Simbirsk Cement.
Because of early termination of the right to use. The point was about civil law, civil private law. But it has not been finally decided yet. It has to be further regulated. There are different other points to be finalized through the efforts of the entire community here. And the main thing, as I said before, regretfully, the sector is behind the business development, the development of the businesses. I think these are all the points I wanted to share. I'm ready to take questions, if any. Thank you, Roman. You have touched upon a very lively discussion of how to qualify the nature of these relations. It's as old as the subsoil-related legislation, with its oscillations between the two extremes. The previous attempts to introduce civil law-based system were not very fruitful, maybe too difficult, if you know what I mean. Things that the civil code tried to implement about the circulation of the subsoil, practically there seems to be some interest out there. On the other hand, there are large risks borne by the civil law-based approach. Why is that? The Subsoil Act has been so steady, no changes after 1991. Is it good or bad? Where 98% of the blocks have been distributed, where basically the subsoil use has been done for a long time already now. Those are long-standing relations. This is a very interesting discussion indeed that we see occurring every year, and I think there is no single right answer to this from the perspective of government regulation. If we look at the overall vector, of course, they are dropping the civil law-based approach. Everything continues along administrative lines, where assessment is done this way by the government bodies. But when it comes to continental shelf, that may be the crucial point there, where, for instance, two subjects holding exclusive rights, actually that means new legislation in place. And I'm using this opportunity to give the floor to our next speaker, Ms. Evgenia Belova. She's involved in regulatory support to shelf projects on the shelf, and she works for Neftegas, which is an international investor participating in shelf projects in Russia. And this block would be complete then, and then we can start discussion, I think. What do you think? Evgenia, you have the floor, and please use the pointer. Good afternoon, distinguished participants. To begin with, a few words about Sakhalin-1 project. Neftegas Limited is operator for Sakhalin-1, being implemented based on PSA terms, product sharing agreement. The company is developing 3 deposits. Sorry for this, doesn't seem to work. Or does it? 3 deposits in the northeast of the island of Sakhalin, territorial sea, and on the continental shelf of the Russian Federation, including both offshore and onshore structures. Technologies involving high-power drilling rigs allow us to use horizontal and inclinational bores over 12 kilometers long. Offshore platforms are designed to bear 20 to 45 drill sections. This is also part of Sakhalin consortium. With them we successfully worked in the Sakhalin region and in the Arctic region as well. During this discussion, I'd like to focus on the problems experienced in Sakhalin. It's been in operation since 2005. As shelf projects started to be operated in unfavorable conditions, where we have some technological, logistical, and other difficult to address issues with the coming of new technologies and the need to upgrade the efficiency and performance of the development of deposits and growing costs of operators. Alongside all these, there is a need to synchronize and update the adequate legal framework for that. Well, I have to make a reservation. We're not going to complain. We don't want any unreasonable privileges. All we want is an open and well-coordinated dialogue on a permanent basis with the federal executive bodies, where the operators could together work on possible solutions. Currently, we have several work sites coordinated by the Ministry of Energy, the Ministry of Natural Resources, the State Duma, and other government bodies, where sometimes irrespectively of each other, independently of each other, people are addressing similar or same issues, while decisions could be made that are radically different one from the other. We would also like to work closer, collaborate better with operators on other projects, to exchange experience in legal activity and in the obtaining of permits, shaping the single approach, common approach, would promote more efficient communication. For instance, different operators could have different subsoil use conditions. Some people could be affected by a problem and others would not. We instead would like to see a single list of problems and optimal solutions to standard situations, because the law should not change because of just a one-off situation. It should provide a comprehensive treatment of problems and issues. Well, I'd like to focus on the key issues and problems that significantly hinder the project implementation. First of all, there is a special problem for us, the need to request the government's permission for multiple border crossings. For one-off works during one navigation, that is doable, although it could take up to 6 months. While for projects already in operation beyond the territorial sea, in a sea, for which you need to provide ongoing communication with the shore, the need to get such permits becomes a permanent need. And getting that permission for a long term, more than a year, is not possible, I regret to say. The example is the operator in 2014 faced a situation where one of the coordinating bodies, government bodies, decided not to okay the multiple border crossing permit for helicopters that carries shifts to the platforms. You will easily understand that's one of critical conditions. That's a vital necessity, and for that, amendment must be made to the legislation on the state border, entry to and exit from the Russian Federation, and the amendments to the tax legislation, because people who work on the shelf based on the open border conditions should not be viewed as non-residents of the Russian Federation, and higher personal income tax should not apply to them. Higher PIT rate should not apply to them. Another problem is optimization of the subject of the State Ecological Examination Commission. The current enforcement practice and the requirements of the law are such that one of the objects of government examination is projected activity in the territorial sea and continental shelf. Based on the requirements of the Town Development Code and Government Resolution 871, the documentation to be submitted for expert examination must contain detailed project solutions, while development of deposits could provide successive drilling of up to 100 drills from one and the same platform, which should be in operation for up to 40 years. In this case, it's just not possible to make one drilling project for 100 boreholes, even in case of typical standardized solutions. Therefore, operators have to many times submit project documentation for drilling wells from one and the same platform because of in anticipation of one and the same impact, and technological solutions and equipment used in the process will be the same. In our view, the optimum way, the most advisable method would be to do government ecological examination not vis-à-vis project documentation, but vis-à-vis the assessment of the projected activity, like it had been provided before for the feasibility study for the construction, or at the stage of declaration of intention, or justification, or the business case of investment, where construction of the boreholes were considered as a method of development, and then this could be, as it is done, the environmental impact could also be assessed. We understand that it is not possible to make a detailed assessment of the environmental impact, but in that case we suggest a more conservative scenario, relying on more conservative approaches and methodologies. But given the current situation, where in a severe climate and severe mining conditions, geological conditions, you have to change project solutions on the go as you drill boreholes, the operators are forced to suspend the drilling to prepare project documentation, 4 months as a minimum, then to get various OKs and permissions to hold public hearings, only then hoping to get the positive opinion of the government ecological examination. That could take a minimum of 8 months. Another controversial issue, we think, is identification separately of the government of plans of eliminating oil spills as the separate object of government ecological examination. We think that such measures, as it was done previously, should be part of the project documentation and provided within the integral package, while as it is now, it is subject to a separate examination. Such plans are developed in line with the documentation issued by the Ministry for Emergencies, which do not contain a section on environmental protection, which basically should be the subject matter for the government ecological examination, and their experts have nothing to consider as such. The plan includes the operative part, telephone numbers, names of persons in charge, algorithms of responding, but no subject of the very examination. While when it comes to projections, like simulation of the oil spill movement, methods of elimination, disturgents to be used, that is actually the same documentation that is already included in the documentation to be subjected to government examination as part of the project documentation. Obviously, this is duplication on the one hand, and the absence of the object of government examination when it comes to oil spills. One other thing, according to the legal requirements, our plans are done for 5 years now, meaning that every 5 years government ecological examination should take place, which by law takes 6 months. Before the examination, you have to go through public hearings and various coordination. You need to add 2 months more. If this 5-year cycle may be reasonable from the perspective of the Ministry for Emergencies, contact persons could have changed, means and equipment and facilities could have changed, but the object of government ecological examination is not there. It was not there, it is not there. Also, generally speaking, these plans are effectively an environment protection measure, and the environmental examination of this kind of measure is not necessary. I think it is redundant, and it adds no value to environment protection, while it inflicts a lot of costs and time to be consumed by the operators. Another controversial issue is the formal application of the legal norms on the territorial sea when it comes to construction of wells with high inclination, where the when the depth could be 25 to 2,800 meters below the territorial sea surface, while no activity is done within the 12-mile zone. There's no impact whatsoever on the marine environment. However, enforcement proceeds from the principle of activity that has to do to exploration of mineral resources in the territorial sea. So it generates unnecessary administrative barriers for purely formal reason. Finally, the problem of government examination of projects to build wells, to build boreholes. We think that project documentation for that should be subject of examination by Rostechnology Agency rather than town development codes. According to information available with us, we need to take. It's better to take those wells from the terms of reference of that, it enjoys understanding with some regulators. However, unfortunately, in practice, nothing has changed. We still to go to the Glavgos expertise for just 1 or 2 boreholes and the platform to get the permits of the Ministry of Construction, and we still have to continue this practice. One reservation, what I'm sharing now is just the top of the iceberg. Another important topic is the technologies applicable. Construction of such wells that we drill do not fall under Russian industrial norms, and we have every time to develop multiple specifications for each individual project. The mechanism to apply standardized solutions already supported by the sectoral specifications is not in use, and Rostechnadzor does not okay anymore the norms that deviate from VNIP standards, and the ministry will refuse them. And STU sectoral specifications must be included in the project documentation. I have touched upon the most acute problems. Discussion is already underway of these, but we want very much that these issues could result in some positive outcome. For instance, making amendments to the State Border Act. Draft amendments had been many times introduced back in 2010 for Stockman. The Ministry of Transportation is also drafting a government resolution to support Federal Law 110, but it only partially resolves the problem of border crossing by seagoing vessels, but not by planes. Also, there is a bill on making government examinations submitted to the State Duma as part of the overall general government examination. We would be happy to share more detailed proposals that we continue to work on, and all panelists here, with all the panelists here, and we would be happy to organize or whatever working meetings to discuss all these things. Thank you for your time. If you have any questions, I will be happy to answer them. Thank you. A brief comment, if I may. The problem with town development examination is already included in the draft bill by the Ministry of Natural Resources, and the legal office of the President approved that last week. So the chances of enacting it is quite high. As regards the state border legislation, there are several initiatives around. Some coming from the Ministry of Energy, others from individual State Duma deputies. Currently, the government has commissioned the Ministry of Transportation to work on this. So very opposite decisions can be possible, and the deadline could be like September 2014. This has been a cornerstone problem, but it has not been resolved for a lot of time. Since this shelf issue is a specialized thing, maybe the audience should have some questions or points to discuss. Please use the microphone as you speak. Good afternoon. Polina Trubachova, Gazprom. I have a question to Roman Vladimirovich. You mentioned that there was a case where the license was issued on the seams. When did it happen? And was it rational, do you think, for this? Yeah, that was an old license, you're right. For production license in the Yamal region, that was a legacy. It's not to be found these days for the reservoirs. Hence my question, you understand it? But the amount of the number of licenses is so high that there are some legacy issues, especially with hard to recover deposits. This is still a relevant problem. There are several approaches to dealing with this. Up till now, the legislation does not address the demarcation of the subsoil block. As for the current licenses, there is a mechanism to change the borders, the demarcation, which are far from perfect, we think. Individual licenses must be identified, and others. The current law prevents from doing that. That's one of the pending important issues in terms of undistributed and retained fund of deposits and third-party licenses and redemarcation of the existing blocks. Translation of the question is impossible. The speaker was not using the microphone. There are precedents of expanding the borders of the block, but if you look at the technical specifications, the current norms are currently in use have to be revised, including the revision of licensing of the commitments of the licensee. Any more questions, colleagues? The shelf is a difficult topic, but you know what? Sometimes I have a question in my mind as to the current developments on the shelf, given the importance and the pioneering nature of legal drafting there. It will have a significant impact on the overall picture of subsoil use in Russia, because even the available instruments like financial collaterals, financial tools for oil spills offshore, it will be replicated onshore as well. And what you raised, the topic that you raised, the town development coding, getting the permits for building, drilling boreholes, they're quite identical, whether it is onshore or offshore. And we need a comprehensive approach to this problem. Actually, we need to take these norms out of the town development regulation. They just stand in the way, and sometimes they are not possible. It is not possible to apply them. More questions, please. Vodokanal, St. Petersburg. My question is this: since oil or gas production in the shelf would involve additional difficulties as opposed to onshore operations, Roman Vladimirovich mentioned that we still have some legacy like wastes. Everybody knows that. What kind of attention is paid to the companies represented in this room in the first place, to the drafting of legal acts regarding environmental safety? And to what extent the companies itself are interested and willing to be involved in the legal drafting? Well, if you take the shelf, amendments that were made to the current legislation at the end of last year, they have created basically a new mechanism of financial provisions, mechanisms to provide emergency oil spill recovery. We actively work with many bodies on the substance, on the contents of the legal acts, and that is not the easiest thing to do, because sometimes there is a lack of understanding. This is not to say somebody is escaping responsibility, but the point is to make the regulation suitable for the state-of-the-art technologies and approaches in use on the shelf. This is what about environment protection. The President has said more than once in public that we need to address the very important problem of protection of historical heritage, and the current approaches prevent from efficiently doing that. The draft law by the Ministry of Nature on that does not contain instruments that would stimulate the companies to be involved in this activity. Such instruments are available. We know that other people use it, and I think companies should be very much interested themselves in doing that. We, for one, are doing this. And then we need to revise some current technological or non-technological standards, the 10% limit of non-performing boreholes. Classification of those by the level of production should have been done long ago, and that needs to be done, where you need to isolate some problems and address them and resolve them. Having said this, the current legislation should not always be used as a whip. Let's take the compensation for damages. Enforcement is not entirely correct there, and the judiciary, it could be doubled in kind plus some pecuniary payments. That's the most important issue that must be addressed now, but it's only addressed, has been addressed and resolved only at the legislative level. So this agenda is really harsh to address, and we understand it and we try to do our best. Well, let me add, yesterday there was a roundtable discussion on environment protection. Do not misunderstand me. A state company like ourselves, of course, will do its best to eliminate the legacy damage, what falls within our terms, a range of responsibility. Just imagine the Moscow refinery plant. It was built back in 1937, okay? That facility over the years has seen a lot of changes. There's a wonderful buffer pond, as you call it. It used to exist there. Actually, it's the sludge storage containing a lot of oil. It started in 1955 and it ended in the 90s. Who should be responsible for that? Of course, we have done what we could. But we had to also, we corrected the previous wrongs, but we were also fined for having it on our books because of adverse impact. We paid 1.4 billion rubles. It's a golden pond. It's not an oil sludge pond. It's a golden pond. Who was actually responsible for that? Not us. We are ready to do that, but the problem is the government is not willing to give us any incentives for that. At least they should have compensated us for the money we had spent on that. No, we had to pay both. We eliminated all the damage, we paid all the money, we incurred all the costs, and we paid all the fines. We are honest and good people, we did that, but there are other things belonging to no one. Just an abandoned pond, an abandoned enterprise. Who would be responsible? Who would be in charge there? If you approach this in a simpler way, of course it's better to have a fund established for the future, but what do you do with the legacy?
I think we need to set up some PPP. The state must either co-finance something or to credit costs towards the spending of waste removing operator. But I think the state is interested in transparent activities so that companies don't avoid paying fines and would clean up after themselves. I think here the answer lies. Pravachova Gazprom. I would like to ask all the presenters, all the panelists, what they think about this. There are lots of issues with our legislation on offshore development. It has not developed since a long time, but there are countries mining offshore since earlier periods. Shouldn't we borrow something from their experiences into the Russian legislation, like countries like Norway and others? Shall I respond to that? In any event, any process of drafting legislation includes the phase of reviewing other countries' best practices and laws. So in principle, this is invariably done. So what we are doing by way of environmental issues, well, it all relies on an analysis of or a review of how this is done in other countries' laws. It is difficult to say. We are trying to follow other countries' best practices. With your permission, we'll go on and hear the presentation of Victoria Romanova, head of the Energy Law Department of the Moscow Law University. Thank you very much. In the first place, I'd like to thank the organizers for the opportunity to take part in this roundtable. I am here in two capacities: as head of a department among the youngest of its kind in Russia, a Department of Energy Law. It was only set up last year. The Moscow State Law University, the Butafin University, is proud of that. The department is made up of practitioners, and the mission we have assumed is, of course, apart from education, is systematizing law in various industries or branches of the energy sector. And I'm thankful to people who have come to our department from the Ministry of Energy, from Gazprom, from RAO. There are practices encountered every day in this or that sector of the energy industry, and the legislation does require perfection. And sometimes, as we try to bring it into a system, even if only to prepare some learning materials or information, students ask themselves who prepared that. And the practice we are talking about today is indeed very important. And all the speakers have stressed the need for relevance in legislative requirements, and have discussed the results of enforcement practices we are having. Another capacity in which I'm here is a member of the Public Council under the Ministry of Energy, and I think that's an advantage in the open discussion of the law we're having today, and the draft laws bills that there may be, and it's a good opportunity for experts both in the energy companies and in government authorities to assure a balance of interest. And two discussions have taken place in the Public Council with 150 companies involved. They indicate it's a great advantage to have such a venue. When I was preparing for this panel, I was asked to tell the organizers what it could be dedicated to, and I thought I would raise a few questions for practitioners. And I really I singled out a few aspects of the oil industry, considering the composition of this panel. It is natural we cannot cover all the issues, but those who have to do with it, both in practical and academic terms, this is one of the most complicated areas of the energy sector, like the power industry, the gas industry, heating, or nuclear energy. There's no core law here that one could rely on, like a law of 69 or 190 on gas supplies or heat supplies. We have no such law in the oil sector, and to systematize the knowledge there is and to come up with proposals for improvement of the legal models, one has to analyze a large number of laws, international agreements, and also bylaws, as well as the rules established by individual companies. My task here is not to cover all the issues. That would take a lot of time, and I would be criticized for that. And what I have taken as basis is a very important discussion which took place on June 4th, 2014 at the meeting of the Commission under the RF President for the Development of the Energy Complex and Energy Safety. And the issues raised there in relation to the oil industry. And I would make only 3 points. Trends in changes of the national law, legal regulation of investment projects in the oil and petrochemical industry in the Far East, and the rules of the functioning of the common oil and oil products market of the Eurasian Economic Union member countries. Well, the Commission discussed, among other issues, it was the bill on the taxation of the financial outcome in oil output from major pilot projects. The bill was prepared by the Ministry of Energy and supported at the Commission. And I should point out that the official website of the Russian president carries the minutes of that meeting, and a record of how the president analyzed this bill and what he didn't exactly like there, with good reason. The main idea was that in the early phase of development, the tax burden should be minimal and then should grow as more oil is produced. But again, linked to the financial outcome. Now, the president of the Russian Federation pointed out that the financial outcome will be minimal and the tax base negligible under the existing taxation regime. And indeed, that was right. Although the draft law was really well written by professionals, it is difficult indeed to expect the financial outcome to comply with the assessment there are at this point in time. Later on, as the bill was discussed, information was carried by the press and the media that it is to be analyzed in the future and adjustments will be made. But this statement by the Russian president is indeed very accurate and to the point. Now, what the meeting focused on as well is the time frames for subsoil use. Some colleagues have already mentioned that issue, and the fact that energy companies keep saying that legal models are in need of improvement here. Now, the time frames are recorded in the administrative regulations, well known to all those present here. The time frames there are included in item 15 of the administrative regulation. It should not exceed 65 days for administrative procedures. Amendments to the license should not exceed 140 days. And this applies to amendments to the license. And in analyzing this paragraph and based on companies' proposals, I would like to say that the regulations include a provision, well, at least I cannot fail to note that this regulation gives a time limit, although 140 days is indeed something difficult to comply with in terms of practice. But there's paragraph 16 has to do with suspension of government functions in case of changes to the Russian legislation and the volition of the license seeker in writing, submitted in writing. But the formulation of reasons for such suspension are very brief and uncertain because in the first case there's no time limit here, and what the petitioner is going to do when it says that government function may be suspended, and it appears it may be suspended for an indefinitely long time. And in the second case, it's in fact termination of the function, because if the seeker wants the petition called off, then it's not quite clear why the government function has to be suspended. I think that even the request for shorter time frames was really voiced at a meeting of the Commission to develop the resource base in Siberia and the Far East. And there's a good reason for that, because what we have now does not add any certainty to a company's operation. When I was getting prepared for this panel, I pointed, also decided to make a point that government regulation affects private legal relations in the energy sector. It is natural that government regulation, state regulation, including that in the oil sector, is due to the need, in the first place, of assuring energy security, environmental security, and anti-terrorist security. That these requirements are there, and those limits exist is correct, and we as end users are interested in having the resources we need with all aspects of energy and industrial security observed, and relevant requirements are recorded both in international and national laws. I could cite the International Convention on the Prevention of Major Industrial Accidents, which came into effect in 2013, on the industrial safety of energy complex facilities, and then conclusion of an international agreement and adoption of national needs understandably establish some very serious additional requirements for economic players. They have to do with industrial safety and the safety of fuel and energy complex entities and properties to assure the anti-terrorist protection. As regards oil producing, oil refining, petrochemical industries, owners cannot lease areas out without areas and facilities out without the consent of unauthorized authority. Of course, it's a restriction of ownership. The owner of a facility must set up systems of information protection, and these are only a few examples, apart from information on categories and everything, something that these are just some of the few things that economic players have to assure. At the same time, when such subjects are faced with major investment projects, projects of long terms involving considerable funding, and projects which are in fact comprehensive infrastructural projects. And I think it is quite legitimate to require additional government, additional state guarantees and measures of support to secure the ownership of companies if they set forth such requirements. So one question was asked about making one project in the Far East a priority, and in this case this application is quite justified. It's another matter that one should weigh up very thoroughly what regulatory act or law can define that status, and the issue was included in the Commission's agenda and is going to become an object of very thorough review. And here we need to probably realize that it depends on what relations are in need of special regulation with regard to this project. Talking of relations that are regulated at the legislative level, well, then, of course, legislation, a piece of legislation is necessary. Now, if there are issues, those are issues dealt with in the urban development code or the land code, of course, some legislative acts need to be prepared. But if it's about relations that are so far governed by bylaws, then the adoption of a bylaw is sufficient. But the practice we are having today most likely will translate into the adoption of a piece of legislation, but that's up to practitioners. And I can only point out what can be done and what questions could be answered. Now, again, the issue of the limits of administrative influence, this is indeed a fair object for discussion among practitioners and academics. And I believe that we could go by the criteria that recorded not in a special energy law, but in the procedural law of procedure. And let me cite the procedural code of commercial arbitration and the criteria a court goes by when it nullifies standard setting act on one of two grounds: that the decision, action or failure to act should not contradict the law, and it should not interfere with entrepreneurial activities. And these are the two fundamental provisions that have to be observed. And then some balance of interest may be assured. I would also like very briefly to call your attention to another issue. It has to do with legislative efforts by way of supranational legal regulation of a common oil and petroleum product market. On May 29th, the Eurasian Union Treaty was signed, and paragraph 3 says that the members should gradually form a common oil and petroleum product market. There's an annex containing a protocol which also contains definitions of terms known earlier because it relied on the 2010 agreement, one which was banned by the Russian Federation for Belarus and Kazakhstan. And I would like to point out that such a common market includes oil production, operation and deliveries in the territories of member countries. The production part is included as it was in the 2010 law. As regards the taxation, it has to do with internal or reciprocal trade, and practitioners should pay attention to that, because when certain relations are classified as pertaining to a common market, then national laws need to be amended. But then the question arises, why is the production sphere or sector is constantly made a common market? But considering that this market is going to be formed and time limits have been set, both practitioners and the government authorities are now to work on on that, because the question is it's all about the practice that follows from the signing of the treaty. Well, I would like to conclude now, because the members of our department are really ready and prepared to help anyone so that regulation of the oil energy sector is at its optimum. Thank you for this presentation. May I introduce Wilfried Bergman, member of the board, European Academy of Science and Arts.
Thanks a lot. I think I would like to draw your attention to more fundamental issues in our range of issues. This is the International Legal Forum, isn't it? As we were working on this topic about 6 months ago, we did not think that the largest administrative barriers across the range would be politics. At that time, when we were just setting the question, what about the administrative barriers? The relevant discussions were about the energy prices. 6 months ago, competition, environment protection related decisions, and so on. While today, for lawyers, those things seem to be aside. Today, energy security is the greatest legal issue. Political attention, because of the Ukrainian crisis, because of the crisis in Arab countries, protection of international energy systems and networks, that is the central point of all the discussions today. And the international political level, and for the international security, the key topic is exactly the international legal issue around energy. I do not see any possibility of us resolving this matter overnight. We're not the UN Security Council, but being a lawyer, I have to say that our challenge is to suggest solutions. I think, and this is true for the Russian Federation, the main topic in this area should be diversification of the energy sector. As opposed to some other presentations made earlier, I do not think that that oil and gas is the principal matter. Legally speaking, many things have been resolved about oil and gas. Oh yes, there are pending issues there. Matters relating to Shelf, Sakhalin. Of course, those are very important issues. But if tomorrow a bicycle drops down in Paris, that is also an important issue for the rider of that bike. But internationally, that issue, the Shelf, it's known to all lawyers as is the regulation of the airspace and the outer space through bilateral or multilateral agreements. The Shelf issues will not be addressed internationally through the efforts of 150 countries. There will be always someone who is opposed to that. It's only possible to have an international regional convention, and it will all depend on the participating countries. The example is the Northern Sea Shelf Agreement. Participating countries are Germany, Denmark, Norway, Belgium, Holland, and the UK. And it was addressed through the convention rather than through general international regulation applicable to everyone in the world. Apart from oil and gas, hugely important is green energy, as we call it. I think there are lots of international legal issues there, especially when it comes to technology for generating energy from water. I think that 10 years, 15 years from now, that will be one of the most important sources if this technology is developed. Why? Because that is a clean technology, resources are abundant, and everybody knows that oil and gas would come to an end sooner or later. So we need to think, as lawyers as we are, about prospective forms of energy for the future. And coming first there is the guarantee to protect the energy networks. Without that in place, we won't be able to get any serious positive outcome. And that cannot be done by any one state alone. I think, and I can tell you, that's another political opinion dominant in Germany. We think that, well, of course, it's all very difficult. Despite all the difficulties between Russia and Ukraine and Europe, we need to seek for legal possibilities to uniform the energy market between the Russian Federation and the European Union. To put it briefly, in Europe, and that has to be done before 2020. Why is that? Unless we have done so by European agreements, other parts of the world will be the sources of difficulties for ourselves. And there are other things addressed by every national state individually, but again, that is an international subject matter. As of now, we pay not enough attention to the fact that energy is a social matter. It's protection of people who use the energy. And I envisage this danger in Europe and in Russia, if people cannot afford to pay for electricity from their pension money to energize their refrigerators, that would be a problem for Putin and Merkel alike. A relevant matter of energy security, energy protection, that's a very important issue. And the legal research its role is next to zero, which is really bad. To sum up, and we saw it, we heard it today from the discussion, it is impossible to talk generically. We need to set up working groups on every individual form of energy, each of which would address the respective legal issues and submit proposals to the respective governments for further advancement. And priority number one, unfortunately, is the security situation. Thank you. Thank you for your presentation. Our first part was dedicated to the continental shelf, and now we're taking more global issues relating to the international aspect. And the closing presentation this afternoon is the presentation by Mr. Popov, Vice President for Legal and Corporate Affairs for National Aggregates Company. He will talk about the regional aspect in the Russian Federation in subsoil regulation. So it looks like we're going to cover all the three major components of our topic today. Good afternoon, dear colleagues. Thank you for staying so long. I'm going to tell you about much less global things. Nothing about energy security or things like that. Just about the normative regulation of subsoil use in particular regions in Russia. Subsoil blocks of federal significance, that was covered a lot, but there are local subsoil where general mineral resources can be found. Stone, clay, sand, without which you cannot build a house or a road or any infrastructural project. Allowing such subsoil to use this subsoil and production of such mineral resources are within the terms of reference of the federal constituents in Russia most of the time. Of course, there is a general legal umbrella, that is the Subsoil Act of the Russian Federation. However, practically all the technical things, including when the licensing procedures, are the domain of the federal constituents, which is where the real fairy tale of creativity begins of our counterparts in the regions. Just to remind you, in a standard way, it all starts with you have a subsoil block and you like it and you want to get it through an auction, most often because regions stopped holding tenders nowadays because of some unpleasant situations. They are under strict control by the General Prosecutor's Office or regional prosecutor's offices and some others, but the procedure looks quite transparent, while on the other hand, creativity of our regional counterparts has no limit. Sky is the limit. I'm really impressed with that. Just to name a few. If you want to get an auction in Krasnodar region, then the auction plan must be compiled at least 18 months before July 1st of the preceding year. It's not any global things. It could be 50 hectares with 20 million tons of sand or lime, you name it. While the plan, of course, must be adopted in the previous year. Regional counterparts are very fond of mixing or confusing land use issues with subsoil issues. It would be logical, at least vis-à-vis general reserves, to combine it, but it has been split by the federal legislation, and regional counterparts try to put it together. Let's take Ekaterinburg and Sverdlovsk region. Before you can get the permission for an auction, and the local department for subsoil use could submit the application to the Rosneft, federal agency for that, you need to bring the consent of the owner, of the leaseholder of the block, or both. And it could be like 20 blocks at the same time, so it is very unrealistic to collect all these documents. My favorite example comes from Krasnodar. Southern people are very creative, aren't they? Where subsoil blocks will only be given you in use if they are located underneath a plot of land owned by the government or municipality. If the plot of land is in private use, you need first to it is not possible. You need to nationalize or municipalize your property, only then you can start producing. If you lease a plot of land, or if you lease a plot of land, you have to give it back, have it become publicly owned, only then you can cherish some hopes. Then information, disclosure of information, it differs from region to region. Most of the time, regions decide that information must be disclosed at the federal website about the biddings. Some regions, however, sincerely believe that is not entirely right, because then everybody would know. Better to place the information at the website of the regional government or local newspaper, or a website of a local unit of a local department. Payments and advance payments, also a nice story to tell. They count one-off payments as such additions to the federal methodology, so that the total amount becomes very different. The minimum amount of one-off payment in Altai should be a minimum of 10% of the extraction tax of the annual production capacity of the enterprise. And it differs from year to year. How can you possibly calculate that? The creative accounting there, again, the sky is the limit. When it comes to holding an auction in Smolensk region, the rules are that at the 100th step, the next step must increase 100-fold. Then everything becomes 100 times more expensive. Why? Because the auction organizers are tired. Moreover, some regions, again, I'm talking about Smolensk region, believe that if the auction bidder appears a speculator and is ready to lose the advance payment, then the license should be given to the second best bidder. No one knows what price should be used for that, but the rule is like this, goes like this. The one who made the previous bidder, the one who made the previous bid. And obviously, virtually all regions prescribe to themselves the right to cancel an auction 2 hours before without any compensation to anyone, and the judicial practice follows if you have a real damage, you can go to court for it, but you have no ground to insist on having the auction held, because it is up to the government body's discretion when and how to hold the auction. The curious case is regulation in Bashkortostan, for instance. They have their own Republican subsoil code, the codified regional legislation, if you like it. Some other cases occur, like the Ministry of Natural Resources of Karelia is a separate legal entity as part of the government entity. You like it. Krasnodar Krai, I think it's the only federal constituent in Russia where lobbyism is officially allowed, according to the law from back of 1995. It's been discussed very sadly at the federal level since long ago, but it's been quite operational and active in Krasnodar for 20 years now. Finally, I understand everybody is tired by now. Some interesting stories about the judicial practice. The Ministry of Natural Resources of the Moscow region managed to make the licensee who won the auction to get the license that they wanted to cancel through the court. Mandatory issuance of the license. How do you like that? Well, let me wind up at this. Obviously, colleagues, regional legislation is something that needs to be significantly improved. And it would be advisable to agree with Roman, he is left, unfortunately, that subsoil users who gets the right to the subsoil should get it not to the center of the earth, but to some clearly determined and defined depth. Because it happens sometimes where there are more than one subsoil owner and subsoil use auction who differ in the depth of their block. Thank you, Mikhail. Just a brief comment that this differentiation by the category of subsoil blocks, regional versus local versus federal, affects oil and gas companies as well. Everybody's interested. It's a superimposition of regulations, entails unresolvable situations, especially where operators' arrangements are in use. This is really important topic, and there is a lot of chaos out there. I'd like to give the floor to Andrei Gennadievich Lisitsyn-Svetlanov. Could you? Yes, please. Thank you. Lisitsyn-Svetlanov, Director for the Institute of Law, Senior Partner for the law firm Ute. I was happy to hear all the previous talks. All of them were wonderful. My subjective pleasure was that all those presentations went along the line of ideas that I had been thinking about, and I'll try to briefly talk about them. Firstly, administrative barriers. A few words about that. Indeed, administrative barriers are a burden for the development of the Russian economy, including in the energy sector. However, currently, on the initiative largely from the controlling unit of the President's Executive Office, there is a draft law being prepared on the controlling and supervisory activity, and an active role there belongs, RSPP, Russian Union of Industrialists and Entrepreneurs, especially metal people there, metal industrialists, but I have not heard about any big interest of that vis-a-vis the energy sector. I think metallurgy is, of course, an important sector for the Russian economy. However, I'm convinced that the backbone of the national economy has been and will be what we have from God, that is the energy resources that we've got available. Secondly, how to structure the legislation, another thing that was discussed here. In particular, how to use the international experience. If we refer to the history 100 years back, before the August of 1914, I could give you, name just one law of the Russian Empire, which is the best in the world, which was the best and has been the best in the world. That's the mining charter of the Russian Empire. That's legal perfection in its true sense. If there is such a thing, that is the one. Of course, in 100 years' time, some provisions, many provisions of that charter have become slightly obsolete for today. However, methodologically, they are perfect. Just to give some examples. Quantitative indicators. The current Subsoil Act, and that's the beginning of all regulation. It's a conventional piece of law, 4 pages, 52 or 53 paragraphs. The mining charter contains more than 1,500 paragraphs, broken down in parts, sections, total codification provided. The second thing, as we refer to the Russian constitution, we say that it is the social state, and it was mentioned by Professor Berman previously in his talk. The mining charter of the Russian Empire contains provisions of social nature that relate to issues such as the upkeep of the families of mining engineers who live remotely from the mainland, in the remote areas, so that the territory of the country is not used as a colony just providing resources, but true colonization of the territory must be provided. And that was what the charter took care of. Secondly, the empire was single and indivisible. However, we were considering cases about particular regions there, didn't we? Weren't we? But the charter contained separate regulations for Poland, Cossack lands of Cossacks, of the great Finland, Orenburg and other places. Then there are some priorities. 100 years back, gold mining was a priority. A wonderful example. 5 ruble and 10 ruble coins were made in gold. That was the actual coins in use. Of course, gold, the importance of gold has changed. We have hydrocarbons and other new sources of energy, but the very approach was very comprehensive, with regulating both oil production in Baku, current Azerbaijan, or gold mining in Siberia. They have to be addressed comprehensively, and that was done 100 years back. Given the fact that the territory of the Russian state was quite unique in this respect, is quite unique, then I think that with all deep respect to international legislation, why don't we look back at the historic Russian legislation? Another important thing, things relating to international aspects. It is true, oil and gas are bound to come to an end sooner or later, but according to the great Lomonosov, nothing emerges from nowhere. Just one type of energy will transform into another. Will we be talking about energy of the wind? You need some territory to install windmills. If you have a stretch of land like 1,000 kilometers long, and it is much higher number of windmills that you can install if you have 10,000 kilometers. If it comes to solar energy, it has again to be transformed on the earth, physical land that we have available. Then again we have to talk about the territory. Finally, water resources, you were quite correct, as you said it before, not just for energy, but just for our everyday life and survival. One of the dangers of the coming years, it is clearly where is the largest resource available. And by the way, about the solar energy, to make it relevant, Vladivostok and the Crimea are on the same latitude. I mean the number of sunny days, the amount of sunshine there. So issues relating to the coordination of efforts in the international area, it also relates to technology, and we can't do without technology exchange. Another thing I'd like to mention, one other thing. If we look ahead a little bit about the use of water, solar energy, maybe even to grow grapes, you need agricultural land to do this. Then the question is risen about how can we possibly use the what we have available today. I'm getting back to hydrocarbons. You know what? It is going to be an eternal conflict. The consumer, if he has the money, will strive to get closer to the source. It's only natural, isn't it? Again, to exercise control and provide for security. It is not dangerous, it is not bad. It's not about capturing things. That is quite a natural trend. And according to Agan Began, the producer will always strive for the filling station, just for economical reasons. This thing, two-sided approach, will exist forever. There was an attempt made, however, to settle that down on the international level. At least it was the European initiative, I mean the energy charter of Europe. It is quite obvious now, in the light of recent decisions. Russia initially said, okay, we would be part of it. Now Russia says we won't, and it was quite correct to say. What do we see as we look at the map? The energy charter, the way it exists, was ignored by the key market, that is the United States. It was not supported by the second largest market, that is China. It has not been supported by India. Norway, however much it is committed to European values, they are quite happy as they are with their own hydrocarbons. And of course Russia has not supported that. The key markets of consumers and producers turned away from that document. But the problem is still there. The problem is still there. Then what about legal traditions? The United States is not a land or state who will initiate international agreements or treaties. Their normal principle is a contract is the land of law, but a contract, an international contract, an international treaty is what reduces efficiency. That has been the case with America. As regards China, well, over the last 5,000 years, China has produced a lot, except in any initiative in developing the international law. So much so for India as well. So the only country remains, ladies and gentlemen, that can be the initiator there, and that is Russia. Russia. Norway, perhaps, if they are willing to. So issues relating to further production or development of international law, international legal regulation for the best interests of the consumers, the way it is currently done in the current charter as it exists today, but with also due account of the best lawful interest of the producers of energy.
And not only producers of hydrocarbons, it's solar energy and everything else, rapeseed, etc. So there will be no one other than Russia to come up with the initiatives. We have a few more minutes for short remarks, and we will conclude. Good afternoon. I'm Lyudmila Kanaeva, head of the Water Law Department of the Ministry for Natural Resources of Russia. I would like to add a few words to the first part of our panel relating to offshore land use, subsoil use. Our department was directly involved in the development of Law 287, which went into effect on July 1st, 2013, and now a few bylaws or subordinate acts are being developed by both our ministry and the Ministry for Emergencies. And I just want to update you. The Ministry for Natural Resources has developed regulations for techniques to provide cleanups to eliminate leaks. It has gone through all kinds of expert assessments. The Ministry for Economic Development has also given its opinion, and other federal authorities. And this those draft regulations have been updated, and coordinating meeting is now being planned to take account of all the comments, and this is what applies to the guidelines. And now also there are two draft resolutions by the government of Russia now circulated to various ministries for their concurrence, 613 and 240. The first draft has to do with requirements for plans for activities to eliminate oil and petroleum product leaks on land, and the second to such leaks in the maritime environment. It is also in its final phase, and the authorities have held a coordinating meeting. A protocol of differences is now being signed, and the draft resolutions will be submitted to the government. And this is about the latest information about what the federal authorities are doing to implement Law 289, which has finalized financial support mechanisms to prevent and remove oil spills and various issues with government environmental assessment, whereas in applying for subsoil use license, this plan, or if such a plan has undergone expert assessment, another assessment is not required. Now, in principle, this is all about the ministry's activities, and I would like to ask the representatives of subsoil users, what do you think of insurance of civil responsibility? Because in 1993 the Ministry of Transport developed a similar bill, but it only had to do with oil transportation on land and in air. But that legislative initiative did not make any progress and was not codified. And now Law 287 does provide for this possibility of insurance. And do you plan to use this financial mechanism? Repeatedly in our official communication with the ministries and when reviewing the initiative for so-called liquidation funds, our company pointed out that it should be regarded as a priority alongside with the mechanisms of uh, amount lodgements, and the company considered it from the environmental perspective as an alternative to the need for 100% lodgement or depositing of funds. I can't hear the question being asked. Well, that was a discussion, but in fact, it's a matter of guidelines and practical techniques. The market will catch up with this. We have a few remarks from the panelists. A small remark, I am not a great enthusiast of those energy maps. There was a project with some in favor of it and others against it. But we've had successful negotiations on such an energy mark, and I believe that we are coming to a compromise in the interests of both Russia and the European Union, unless politics interferes. And the second thing I was going to say is that I do understand a feeling of patriotism, but on the other hand, I also appreciate Mr. Putin's words at the latest Petersburg dialogue. That globalization issues can only be resolved together and not alone. Now, the remark being made now cannot be translated. The interpreter cannot hear. The speaker is not using a microphone. You people. If you have a railroad, it is common between Russia and Germany. So I support Mr. Putin and your remark. Putin's and your remark. I have a small remark on Ms. Kanaeva's remark about insurance. Our company works with surface deposits, but the issue of insurance, we used it in relation to water use, and there was a draft law drawn up, but then a problem arose that any insurance company, whether big or small, needs to have certain insurance funds as required by Rosneft, and as was found by our experts, no insurance company, not even an insurance company pool, can assume such tremendous risks because the insurance services market in Russia is not adequate, and that was probably the reason why we ruled that out. And I think that the same issue exists in subsoil use. Yes, indeed, and there the amounts are even greater. But when they debated the institution of depositing funds, then of course it was stated that we should look for insurance, because otherwise any project will go beyond any limits for a payback period. Excuse me, we know the insurance issue very well in Germany, and we decided to build a fund with contributions by oil and gas companies and government protection, because it is impossible to have it without government guarantees or protections. No major company can assume such a risk. Russia has a similar institution, the mutual insurance company, but it is underdeveloped so far. To sum up today's discussion and dialogue, I need to remark that starting from practical issues of concern to people in the field and ending with the international issues of a high level, which we also discussed today, the St. Petersburg Forum is an excellent venue for us to exchange views and see the relevant topics and the entire range of issues of concern. And I hope that this will help make progress, more specifically because the initiatives we have voiced and explained today, which are receiving government support, I think the discussion was very useful and good. And I thank all the panelists and colleagues for these 2 hours we've spent together, and I wish everyone success and this in your work at this forum. Thank you.